Chris Hipkins.
Thank you very much, Mr Speaker. Very happy to take a call on this disallowance motion. I just want to, before I get into my substantive remarks, respond to one or two of the things the Minister has raised and put out a few points of clarification. The first point of clarification is this. All of the decisions on this entire examination of these matters by the Regulations Review Committee have been made unanimously, with support of government and opposition members on that committee. It's been entirely unanimous, and the other point that I want to raise on that is that the board were given an opportunity to reply. So it wasn't like the committee was considering the submissions in isolation without providing the board an opportunity to reply. They were certainly given that opportunity. The third point that I would raise is a disappointment that the Minister is informing us the government are going to vote against this because the Minister had several options open to him, one of which was to engage with this process earlier on. He could have. He was informed of the committee's consideration of the matter. He would have been briefed by his officials. He could have intervened at an earlier point, made submissions to the committee. He chose not to do that. He chose not to do that. The second thing is, coming to the House today, if it's timing that he was concerned about, he could have dealt with that issue with an amendment in his name that would have delayed the issue regarding the competence requirements, the professional development requirements, and he chose not to do that either. So instead he's chosen to throw out the recommendation of the Regulations Review Committee altogether. I think that's actually a very serious step for the government to take, because the Regulations Review Committee is a very, very important part of Parliament's processes. A lot of governing in this country is done by regulation without scrutiny by the House as a whole. We rely on a small committee to do that scrutiny function on behalf of the House. Therefore, when that committee, given the very narrow grounds that it has under the standing orders to scrutinise regulatory decisions, when that committee makes a unanimous decision to the House to disallow regulations, I think that's something the House should take very seriously. And I'm very disappointed that even though the national members on the committee voted unanimously in favour of the disallowance motion, the government are now going to use their power to block the disallowance motion. The reason that the committee made the unanimous decision to disallow these regulations is because we did not think the law had been fully complied with. Now, because those are the only grounds upon which the Regulations Review Committee can do that. They're set out in the grounds that the committee can do that are set out in Standing Orders 310. The grounds that regulation can be disallowed are point 2A through to I, sets out the grounds in which it can do that. Now, I want to acknowledge that a variety of concerns were raised by the people who first asked for the committee to consider the matter. A variety of issues have been raised by master plumbers, a variety of issues raised by the board. It would be fair to... Well, they've corresponded. They have corresponded. I can certainly concede that, although they had the opportunity to make a submission. They could have put a submission to the committee. They didn't. They could have put a submission to the committee, but they did not. Now, they have corresponded, and I think that they've raised some legitimate concerns. Having said that, I think that the step the government are taking is the wrong one, and I actually think the Minister would have been better to move an amendment. But I do want to go back to the issue here. Some legitimate concerns have been raised on both sides. I think the people who have raised concerns to the committee, they have raised concerns both within the committee's delegated authority under the House and outside of the committee's ability to investigate. There were some of the concerns they raised. The Regulations Review Committee simply doesn't have the power to investigate those. That does not mean that they're not valid concerns, simply means that the committee doesn't have the power to investigate them. The board itself has acknowledged that things could have been better, and as both the Minister has said and the Chair of the Regulations Review Committee has said, I think the board is certainly doing very well at shaping up its act. The chairmanship of Hazel Armstrong, I think, has been commended on both sides, and I think they're getting their house in order. And that's something that we all acknowledge and all welcome. And the history has not been flash, and it's good to see that they're getting on top of that and that they're actually dealing with those issues. But the issue, of course, from the committee's perspective is we can only intervene insofar as the standing orders allow, and many of the concerns raised with regard to decisions that have been made fell outside of the competence of the committee to examine those. I do want to acknowledge the mixed views that exist within the industry itself. As constituency member of Parliament, I've been approached by people with very passionate views on both sides of the debate. It is not the role of the Regulations Review Committee to determine, to pass a judgment on the desirability or otherwise of decisions that are made under legislation. That's not within the committee's ambit. The committee's ambit is to ensure that the laws, the delegated authority, the processes are complied with. The desirability or otherwise is a wider judgment. That judgment predominantly rests with the minister concerned and with the government. And if the minister concerned or the government are unhappy with the use of the delegated authority, then they have the ability to influence that. The Regulations Review Committee does not. As long as the law has been complied with and the appropriate process has been followed, then the Regulations Review Committee cannot intervene. And I think it's important that the people who have made a complaint to the Regulations Review Committee and perhaps feel that we did not examine all of the aspects of the complaint are aware of that distinction. Our ability to investigate is quite narrowly constrained and narrowly confined. And I think the committee looked at this matter very diligently within the constraints of our terms of reference and within the constraints of what the standing orders allow. So I guess the final point that I want to raise is that the onus really now rests with the government. They are ultimately responsible now for what happens with regard to the board, for supervising the performance of the board. I accept what the Minister has said around the performance agreement that he has put in place with the board. I think that's a very good step. Again, I want to acknowledge that the board do seem to be improving what they're getting up to. And I also say that to the members of the industry that are dissatisfied or unhappy with this regime, that the onus, the responsibility really is one that they need to raise with the government, not with the Regulations Review Committee, and I hope that the Minister will take on board any concerns that members of the industry who are still concerned may want to raise with him, and I'm getting an acknowledgement that he will do that. So that's basically all I had to contribute on this particular debate.
The question is that the motion be agreed to. Those of that opinion will say aye. Aye. Contrary, no. Aye. Noes have it. Party vote. The clerk will conduct a party vote.
New Zealand National.
58 votes opposed.
New Zealand Labour.
42 votes in favour.
Green Party.
9 votes in favour.
ACT New Zealand.
5 votes opposed.
Maori Party.
2 votes opposed.
Progressive.
1 vote in favour.
United Future.
1 vote opposed.
The Honourable Chris Carter.
1 vote in favour.
Honi Harawira.
1 vote in favour.
Any other votes?
The ayes are 54, the noes are 66. The motion is not agreed to. Call